Hello. This is Attorney Mike. I'm coming to you from Chicago. As usual, sorry we had a slight delay because we have a last-second edition from an undisclosed source. I hear it's good stuff. I haven't seen it. It's it's entitled "Idiot in DeSanto's Court." you could title a lot of videos that, but if you're gonna choose that title, I'm thinking it's probably good. Let's give it a look here before we move on to the main event.
Been in custody for 2 days. Thank you.
Mr. Medina, you're telling this court through your attorney that you do not know who the victim is in this matter. Is that what you're saying?
The one. What's that?
Who's Yolanda?
She's a girlfriend.
Okay.
And the mother of my child if we were pregnant.
I'm sorry?
And possibly the mother of my child if we're pregnant.
I like how he's wise enough to say possibly.
Possibly the mother of your child if she's pregnant.
Yeah. And I could possibly be a father now.
Okay. And so, all right, Detective Sergeant Grote, your name for the record, please.
Your Honor, Detective Sergeant Ken Grote.
And as to bond.
Your Honor, as far as the criminal history goes, Mr. Medina's been arrested several times. I spoke with the victim, Yolanda, at length. She feels like she's a prisoner in her own home. Mr. Medina controls her phone. He actually put a lock on her phone so she couldn't call me. I had to have her transported to the station. She was trying to get into the phone through the phone company. She says he controls every aspect of her life. She's not allowed to leave the house without his permission or him following her. She does not want him back at the house. No contact with him, no third party, nothing like that. We'll ask for $1,000 cash bond to reassure his appearance in court and to make sure he stays away from her.
I ain't got a problem with that.
Well, good. You're going to write down the code for her phone right now for the detective.
It's not a code, it's a like a design.
Good, draw the design out right now for the detective.
With that?
I'm sorry?
I don't have a problem with that. To show him the design. It's not a
Good, you're
code.
going to draw the design right now for the detective.
Okay. The thing is like this, right?
Yep.
I like it goes like this, like that, like that, like that, like that.
Oh, this is fun.
Okay.
I ain't got a problem. She told me
It goes like this and that, and then there's a little flourish here.
she put me in charge of it. So that's what
No, sir. Remember I told you nothing
Sir?
about the facts, sir.
If that turns out to not be the code, I'm letting you know, if that turns out to not be the code, that will be a bond violation.
looks like.
It looks like it.
I'm just informing you, sir. If that turns out to not
We're in a goddamn Monty Python sketch.
be the correct code, that will be a bond violation.
That's okay. Looks that's the code. I don't have a reason to lie. And I'm not lying.
Well, you've already indicated that your credibility is already in jeopardy because you claim that you don't know the victim in this manner. And now you're saying that maybe she's pregnant with your child. How is somebody pregnant with your child if you don't know that person?
I never did. Of the current charges that I never did.
Sir, this is not going to work very well if you're talking while I'm talking. So I missed half of what you said.
I'll be quiet.
Judge, have you ever heard of one night stand? I'm trying to help here. I'm offering assistance.
No, you can speak when I'm done speaking. So what I'm saying is that I missed half of what you said because you were talking while I was talking. And I couldn't hear what you said. So what was it that you said?
I couldn't understand who it was. Because I didn't attack no one.
Okay. So let's see, I show a criminal conviction of 19th District Court for larceny. You have felony stolen property dismissed out of the 36th District Court. You have a slew of charges from E-Course in Detroit from 2009. In 2014, do you know what happened with those, sir?
I took care of it.
What does that mean? You took care of it?
I stopped and took care of it. I just paid everything that I had to pay. And sold up to court. If
I
it
understand,
was
sir.
possible.
I took care of it. I got convicted. I went to jail. I paid fines. You know, I took care of it, Judge.
I don't know. That's not under my control. That's under your control or whatever it was. I'm
Sir,
not understanding the question.
you said you took care of it. Does that mean you pled guilty? Does it mean it was dismissed? I mean,
I don't
was it
remember.
reduced? What?
It was.
I'm sorry?
I don't remember. That's how far back it was.
Okay.
I don't recall. I don't know. I don't know if this chick, I don't know who she is. She may or may not be pregnant with my child. What's hard for you to understand, Judge?
With this new change in these set-asides, that's a disastrous debacle for criminal histories and being able to see what's going on. But
Your Honor, I apologize to the court. My client told me he had never had a criminal conviction. So lying to his lawyer isn't going to get him very far.
no, I understand, Mr. Serrano, you're zoomed in from home and you do not
I
have
told you the truth. I took care
the
of it.
benefit. Mr. Medina, I've already said, please stop talking while I'm talking. So for the record, Mr. Serrano, you do not have the benefit of having the file, the actual file, because this was in custody that we had to contact you to zoom in to represent Mr. Medina, and you do not have the file at your disposal. Sir,
Correct.
where is it you work?
Please say Planet Fitness.
Where does you work? She wants to know where you work.
I don't work.
Of course. Of course.
You don't work?
No.
How do you support yourself?
My benefits.
Your benefits? You receive disability benefits?
Yes.
And what's the nature of your disability?
He can't brain.
I don't know.
You don't know?
No.
How long have you been receiving benefits?
Since I was little.
11? Okay.
Little.
And it
Since I was
says,
little.
it says here, I'm sorry?
Since I was little.
Okay. It says here in your marital status that you're married.
No, that's incorrect.
You're single?
Yes.
Judge, he's available. He's single and ready to mingle.
Okay. And you live with your mom?
I live on Homer.
And how long have you lived there, sir?
And I moved to Davis. And now I gotta move back to Homer. With my family, because that's where I originally came from.
Sir, let me ask this another way.
I
How
don't
long have you
understand.
been living on Davis Street?
For one summer, 2 summers, and a winter. That's how long I've been there. 1 summer, 2 summers, and a winter.
So about a year and a half or two
As
or 2
long as,
years.
the last job I had was Workbox, and before that, I was working at Minuteman, and I was working for GFL. I'm not working for GFL, but the staffing agency that I work for sent me to GFL, and they terminated me because I got injured. And I told them that I needed to sleep and to come back the next day, and they didn't understand that. Is there anything else?
Yes, I'm trying to figure out where you actually,
The way I read that is he told his boss mid-shift, I need to sleep. And they didn't understand it. Right. Because you're at work. You're supposed to finish your shift and then go home and sleep.
reside because I have 2 different addresses for you.
Those are
And
only
I
2
was
I
told-
reside at. And where I've been at, that's my history.
Sir, you indicated to your attorney that you live in Detroit. However, you just indicated that you have resided in Wyandotte with Ms. Cavazos. So,
He just responds with a look of shame.
I don't know what's going on.
well, sir, I don't know where you live if you don't know where you
Mailing
live.
address is what I'm telling you.
What's that?
That's my mailing address, and my mail is on hold because of that. So what do you want me to tell you? I'm telling you the truth.
Which is
You
your
can ask-
mailing address, Davis or Homer?
Both. That's where I be at.
I might have to change the thumbnail to this for this stream to that's where I be at.
Sir, you can't live at two places. You
I
can
moved
live
up
at one
home.
and stay at another or go visit or what have you, but
I'm just calmly telling you.
do you have belongings at the Davis Street address, sir?
I got belongings at Davis Street, ma'am.
All right. And if you were to test today, sir, is there anything in your system?
Like as far as,
Like what?
I'm not understanding that question. Can you explain
So
to
if you
me?
were to, if you were to drug test today, is there anything that would show up?
Oh, possibly marijuana, but I don't know. I wouldn't know
I'll take that as a yes.
that question and how to answer it to you.
Do you have a valid prescription for marijuana, sir?
I got counseling from what is it? Southwest Solution Counseling that I'm taking medication. As far as the doctor goes, that's giving to prescribing it to me.
Okay,
That I
so
got
you don't currently have a valid prescription
Yes, I do.
for marijuana?
Yes, I do.
Okay,
Then why didn't you say that?
all right, the court's
I don't
going
believe
to order a $10,000, 10% bond in this matter. The court wants to ensure the safety of the defendant and to make sure that the safety of the victim and to make sure that the defendant is going to appear. I'm sorry, what is that, sir? Because I'm still talking and I can't hear what you're saying.
Definitely stuff in my system. I'm answering your question. I don't have that in my system. I don't know what to tell you.
You don't have what in your system?
Your question to you asked me.
You have.
If I'm currently on anything, the only thing I'm on is my medication. And the food that
Yes, I understand that, sir. I understand that. The court's issuing a $10,000, 10% bond with the following bond conditions. You are not to have any contact with Ms. Cavazos. That's phone contact, text message, email, social media, third party, anything of the like. Let me be very clear, sir. If bond is not posted and you are down at the Wayne County Jail, What I've learned recently, based upon other individuals' alleged violations, is that there is a tablet and that there is a phone. If you are communicating or attempting to communicate with Ms. Cavazos in any way, that would be a bond violation, sir. And if you did post bond, it will be revoked. If you
Am I
did
allowed to
post
grab
bond,
my belongings?
please.
Go ahead, I'm
let
sorry.
me finish.
Go ahead, Steve.
If you had not posted bond and you're still trying to communicate with her, the court will make sure that you do not have any form of communication available to you. Do you understand that?
Yes.
You're not to enter the home on Davis Street. You are allowed one visit to the premises to obtain your personal belongings, so long as you are accompanied by the police. What that
Okay.
means, sir, is that you contact the police department first, and then they will go with you to the home. You don't go there and then call the police. Got it?
I got it.
You're not to possess or consume any alcohol or drugs that are not prescribed. That includes marijuana. You're indicating that you are prescribed marijuana. You have to provide proof of any prescriptions that you may have, sir. You're not to possess or have access to any firearms and or any weapons. Do you have any weapons, sir?
No, ma'am. I don't like
You don't have any guns?
no guns, ma'am. I don't like
Okay.
guns.
The court will also note, in the event you do post bond, you are not to be released without GPS tethered through the Wayne County Jail, and the court will note house arrest, as you're not currently working. Any questions, counsel?
Nothing further, Your Honor.
All right, and we'll see you back next Thursday, Mr. Medina.
Yes, Mr. Santos.
Thank you, Your Honor.
Thank you. Have a good day. Off the record. Thank you, Mr. Serrano.
You're welcome, Your Honor. Thank you.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
Oh my good Lord. I never thought the guy smoking glue when he thought he was smoking crack would be topped, but this guy might have done it. He might have done it. All right, now on to our regularly scheduled program. This one's out there too.
All right, next I want to take Taylor Flick and Isaac Bondurant, 21-19408. There we have Ms. Bliss representing, yep, there's just Ms. Bliss's.
I want to thank Saw for sending this to me. I got into this and I couldn't look away.
Present representing, pardon me, Taylor Flick. And is Isaac Bondurant on the line today? Isaac Bondurant?
Yes, sir, I'm here.
Okay, welcome to you, Mr. Bondurant. Give me just one moment as I pull up my notes, and I apologize. Okay. This is comes before the court on Ms. Flick's motion for adequate cause to modify a parenting plan. We were here before, and Mr. Bondurant asked for some additional time, and I've read his pleadings. And so I think we're ready to go. I'll hear from Ms. Bliss and then from Mr. Bondurant, please.
Thank you, Your Honor. And for the record, Carly Bliss on behalf of petitioner Taylor Flick, who is the moving party before Your Honor today. As Your Honor summarized, we are before the court on my client's request for a modification to the parenting plan. There is also a request for a restraining order. Both have been heard by the court or reviewed by the court, I imagine. One question preliminarily, did Your Honor have the opportunity to review my client's reply declaration that was sent over very late? It was yesterday. So there is that issue.
Yeah, let's see. I wasn't in the office at all yesterday.
That'd be a no.
I was handed some proposed orders, so I think the answer is no.
Okay, and that's fine. I have no issue proceeding regardless. There was some objection that I contained within that declaration, so I would just note those for the record as well, for Your Honor. Mr. Bondurant provided my summarization of nearly 100 pages of responsive declarations, pleadings, exhibits. I don't know the exact number off the top of my head, but there was significant statements provided. I would note that his responsive declaration was, I believe, 27 or 28 pages, single-spaced. Obviously, that goes beyond Local Rule 88. Also contained within his pleadings were exhibits which appeared to have been declarations prepared by other folks, not sworn under penalty of perjury. Obviously, those are inappropriate as well, so I would ask the court to not consider any of those pleadings. Further, I did make a request that the court not consider any of the pleadings provided by Mr. Bondurant, given the fact that Your Honor did give him a firm due date of October 10th. Those were not provided to the court until October 17th, nor provided to my office until October 18th. So those are my preliminary requests today, obviously deferring to Your Honor. If I need to go into more argument, I'm more than happy to if Your Honor is going to consider any of his pleadings.
No, that's fine. Thank you. So let me just touch base with Mr. Bondurant. Mr. Bondurant, there is your submission that was filed on October 17th.
Oh, let's do.
And it looks, I counted 26 handwritten pages of basically your statement. And then you had a declaration from.
You had me at 26 handwritten pages. That's a hard no. I'm not reading it.
Another individual. And so there's page limits that are which kind of makes sense, because when I get a 149 page pleading just for one setting, for one case, that's a lot. And as you've seen today, there's about 20 cases on today. So there's necessarily some time constraints. And so those rules are in place to say, hey, look, we've got some page limits here. And so what I did, I kind of gave you the benefit of the doubt. You submitted 26 pages of your declaration. I stopped reading at 12. And then the other individual, they needed to make their declaration under penalty of perjury. And that gives the person puts them on notice, like, hey, what I'm saying here is really important. I have to be factually correct. And that was.
I really don't know if you guys can tell me in the chat. He floats back and forth the whole time. I don't know if that's like a background. It's a weird background if it is. It looks like it's the natural thing, but I can't explain the movement.
Absent. Their reply didn't have that. Secondarily, their reply was too long, needs to be limited also. So I read a portion of that and then I stopped because it was beyond length. But Ms. Bliss raises a good point as far as the under penalty of perjury language being absent. So I just want to give you a voice to that issue. So if you want to address that just briefly, Mr. Bondurant, you can.
Yes, Your Honor. What I can say is I'm not an attorney. I have no skill in that department. I do know it's very hard to summarize. I mean, to you guys, it seems 26 pages seems like a lot when it comes to your children, but that was the beginning. I mean, these kids are my whole world, so that was easy to sit down and write this about my kids. I mean, and if, Your Honor, if all you were able to get through was 12 pages of my declaration, but you were able to see all the pictures, it's clear to see who I am as a person, what's being pressed that is incorrect. It's stuff to just diminish.
This argument, probably no one's listening, but this argument is just too much for me to take. If you get through the first 12 pages, it's clear to see what an awesome person I am. I'm confident both in my awesomeness and my ability to convey it, even if you didn't see it all. Sweet Jesus.
My name, all this can be proven. I have proved all of it. She said I was pulled over for a DUI, probably on drugs.
So we won't go into kind of the specifics. I just wanted to give you a voice on the issue of kind of the overlength. So I've kind of told you where I'm at, and so that's great. I appreciate that. You'll have opportunity.
Yeah, I just wanted to tell you it was too long. That's as far as I wanted to go with this conversation.
We discuss in detail your concerns. So I'll turn the time to Ms. Bliss.
Thank you, Your Honor. And before the court, obviously, it's my client's petition to modify the parenting plan, given the significant concerns my client raises in her declarations. I note at least 6 different major issues that she reports in her declaration to give rise to this motion and this petition. Looking first to the DUI, my client provides in her declaration and within her exhibits. At that point, all she had available to her was a screenshot of the booking information, and that is contained in my client's, I believe, Exhibit 1 of her initial declaration, indicating Mr. Bondurant was arrested in Springfield, Oregon, or thereabouts, under the suspicion of driving while intoxicated. My client raised significant concerns regarding this, as Mr. Bondurant had also had a DUI back in 2016, to which he was on diversion for. I understand that his diversion has since been revoked and his license has been suspended. On that same vein, my client provides significant concerns. There are video and photographic evidence of Mr. Bondurant continuing to drive with the children, continuing to drive while smoking marijuana, continuing to drive with the children not in proper safety restraints, not in booster seats, in the front seat, on his lap, and the like. The fact that Mr. Bondurant fails to protect these children, these very tender age children, ages 5 and 4, to that extent is just the tip of the iceberg. Very concerning. It's my understanding that his license has since been suspended. My client is requesting specific language that prevents Mr. Bondurant from driving these children at all, at least for the foreseeable future, especially given the suspension, especially given his attitudes towards the suspension. My client provides that he is very active on social media. I think even his responsive pleadings indicate this. If Your Honor were to review any of the videos provided regarding this issue, it's very telling that Mr. Bondurant is defiant towards authorities, is defiant towards court orders. Obviously, driving while intoxicated speaks volumes for itself. Looking next to the
Okay, now I want to see this. I want to see him going off on social media about he's not going to let the man tell him he can't drive drunk. I want to see it.
verbal aggression, derogatory statements, and the like made towards my client, not only in front of the children, which is disturbing enough, but also, again, on social media, referring to my client in very derogatory names. My client provides there's one specific incident back in July when Mr. Bondurant and his wife came into her home to retrieve the children, started screaming profanities at her, calling her a effing bee in front of the children. Again, these are very tender age children. This behavior is completely inappropriate, and there does need to be some limitations contained in the parenting plan that prevents this from continuing. Another issue brought forth in my client's declaration and is very concerning is the overly sexualized behavior that is being exposed to the 5-year-old child in this matter. There's discussion in there regarding the 8-year-old stepchild of Mr. Bondurant French kissing the 5-year-old in this matter, grabbing her face, not letting it go. My client indicates she's questioned by their 5-year-old what French kissing is, why her sister had done that. And Mr. Bondurant's statements are essentially dismissive, that never happened. Why weren't the police called? My client provides in her responsive pleadings filed yesterday that the police were called, CPS were notified. It's her understanding there are active investigations regarding that issue. But the fact that it is so dismissive leads my client to believe either Mr. Bondurant's household is condoning that behavior or they're simply just not supervising these young children, both of which are equally as concerning. Obviously, there was a contempt brought forth before the court to have my client retrieve the child. Mr. Bondurant kept one of the oldest child, for upwards of a month and refused to return her, but for that contempt motion being filed. Obviously, that is deeply concerning. My client also provides for the court the continued detrimental statements being said to the child. Upon receiving the child from Mr. Bondurant, the child expressed fears, nightmares, saying that Daddy and Mommy Courtney were going to kill my client, drown her in the river. These are very concerning statements, again, for any child, especially a 5-year-old child. A child that is now expressing fear having to go back to her parents' household, given those significantly concerning statements. And lastly, but most concerning, was the overdose in August. My client provides for the court that she was notified, did independent research to learn that Mr. Bondurant and his wife consumed fentanyl-laced cocaine. I see in Mr. Bondurant's responsive pleadings, he indicates it was a fentanyl-laced joint, marijuana. However, also contained in my client's reply declaration is there's ring cam footage from the date that Mr. Bondurant was released from the hospital, came to my client's home, indicated he came to quote unquote show the children that I'm not dead, and he went over to a home and did a little bit of cocaine that, unbeknownst to him, was laced with fentanyl. Again, the minimization of drug use, whether it's legal substances as marijuana or illegal substances as cocaine and fentanyl, both are equally concerning. My client provides significant documentation regarding the marijuana usage. Mr. Bondurant holding up bags, gallon bags full of marijuana. Again, whether it's a legal substance or not, the children should not be exposed to that. My client has concerns that there is some illegal activity within the home, selling of drugs. Obviously, the usage of cocaine and fentanyl, either at Mr. Bondurant's home or his neighbor's home. The circumstances surrounding the overdose are equally as concerning. Obviously, if he was allegedly at his neighbor's home, started to feel unwell, as he put it, was leaving said home and essentially collapsed outside of his home. Narcan needed to be administered to save him. He was rushed to the hospital, was in the hospital for a period of time. All of this is deeply concerning, and the fact that Mr. Bondurant is minimizing the effects of not only this on his life, but on his children's life, who could have been exposed to this. There were children, my client's understanding, within the home when this incident occurred. Again, having this type of drug use with these tender-age children and not having any sort of safeguards in place are very concerning. So the request before the court today, from my client's perspective, is to either suspend visitation, which is currently the status quo with the restraining order, or require professionally supervised visitation pending a substance abuse evaluation. I note in Mr. Bondurant's responsive documents, he indicated, he's in some sort of treatment or is undergoing some sort of UAs, hair follicles. None of that has been provided. So there's no way to determine if there is any sort of sobriety. He claims, they only tested positive for marijuana. Again, my client would argue that's also inappropriate, especially given the tender age nature of these children. But frankly, there's nothing to substantiate any of his allegations or any of his claims to prove otherwise. So what there is before the court is substantial documentation, substantial photographic video evidence that there are some significant issues here. So we are asking the court to find adequate cause to modify the parenting plan given the various concerns I've just provided and recapped. I think a guardian ad litem is probably appropriate in this matter, especially given, again, the tender age nature of the children, the severity of the concerns provided, and that is, we're asking the court to order professionally supervised visitation pending that substance abuse evaluation, pending proof of sobriety, and pending a further word from the guardian ad litem.
Thank you, Ms. West.
Okay. I think that was a solid argument, top to bottom, and delivered well.
Mr. Bondurant, I'll hear from you, please.
Yes, so I guess I'll start with the overdose. That is still active, an active investigation. The story behind that, our kids were not at the house. My wife's mother was here. We had gone over to my friend's house, and yes, we smoked a legal joint, which is we are allowed to do. It had gotten passed to us, and it happens all the time. Talked to him at the hospital. Somehow it was laced with fentanyl. The guy's vehicle was impounded. He had belongings taken from him that day. I did not. They were allowed into my house, and they found nothing. This is an investigation into a poisoning. Okay, that is all that is, and that is public information if the lawyer would do her research, on top of the fact that, excuse me.
I don't know. Appears like she did and did a damn fine job. Then did a nice job with presentation after that.
This is being taken. She's trying to paint a picture like I'm just this terrible human individual. That is not the case. She references me being a drug dealer, me holding up gallon-sized bags of drugs. My friend, he grows for a dispensary, and it was 2 Ziploc baggies, approximately about a pound of marijuana, and I took a picture of it. I also have a TikTok where I goof off. I portray myself to be one way. It's social media. You could be anyone you want to be, okay? and they're just trying to spin any video they can, anything they can against me to paint this picture. Oh, also my arrest, she's referring to the DUI.
Yeah, Judge, it's just a character on my TikTok. On my TikTok, I'm a felon and an a-hole, but in real life, I'm awesome. Just read the thing I sent you.
I was arrested for a warrant for an old DUI when I was still actually married to Taylor Flick. I just hadn't taken care of it, so when my wife got pulled over, they ran my name because she has a protection order against her ex, and they had to make sure I wasn't him, and it came up that I had a warrant out for my arrest. So I was arrested, taken to Lane County Jail, and extradited back to Oregon. I have since taken care of all that. I'm not on probation. I'm not wanted in Oregon. And as it pertains to video evidence of me driving around with my kids and not in car seats and not safetied up, that is also not the case. These are pictures of just sitting in a car, a stationary car, and I'm doing TikToks and I'm taking pictures with my kids. I do not smoke marijuana in the car with my kids. My wife drives 99% of the time. I haven't gotten behind the wheel in 4 months, especially after my arrest. I definitely don't play around with it because yes, Your Honor, I am revoked. There's so much that is being portrayed in these by Mrs. Flick. The day that she says that names were called, we actively called the police on her. Her mother assaulted my wife, and because it was 3 against 2, the charges went nowhere. I don't even know, again, I'm not an attorney. I probably sound all over the place. I don't get paid to be an attorney. I'm just a dad that's trying to make sure he doesn't get railroaded by the courts on something that a picture is being painted that any amount of looking into, you could see the truth.
I'm just getting railroaded here.
Of documents, but if you read the whole thing, which I'm sorry you didn't, it states everywhere. She's making claims against me. I'm proving myself. That's what it says in there. That's what these pictures are. The CPS when CPS was here, the CPS case has already been closed. It's been closed for about a month and a half. We're just waiting for the paperwork, and we'll be able to show the courts that I am in treatment, and it's not for cocaine use because I've never had a cocaine issue. I had my appendix removed. I had surgery, and I was on pills, and then I did for a while there. I did get out of hand with pills, so I made sure on my own I went into Ideal Options.
Okay.
And
okay, so I did. So I did get out of hand with pills, and yeah, there was fentanyl in the joint we were smoking. Mm-hmm.
Sought treatment, and I've peed clean because I don't do drugs. I will submit to a hair follicle. That's fine. And a guardian litem. That's fine. I'm not a super good talker, Your Honor, but.
Okay, I'm assuming that's a yes. Okay.
People actually coming here, seeing you. CPS knows who I am as a father. Taylor knows who I am as a father.
If CPS knows who you are as a father, that's not a good sign. I mean, that's no flex, my friend.
This is purely out of spite, and unfortunately, we're in Washington State, and I'm a father here, so we know how that goes.
How does that go? I don't know how that goes. How does that go?
I won 50-50 custody of my children. She didn't show up to court. Okay, I was awarded 50-50 custody for a reason, because I am a stand-up dad, because I provide for my kids, because I protect my kids.
Judge, that's like an A+. Okay, I love how he explains. No, that's the default position, and I love how he's trying to explain it to a judge who actually makes those determinations.
Kids, that's who I am as a father. Taylor knows that, and at the end of the day, the courts are going to make whatever ruling they want to make. I haven't seen my girls in almost 4 months, and you guys are expecting me, the courts, Taylor, anybody expecting me to live any kind of a normal life when the only piece of normalcy I have, she's been able to take
Nobody expects you to live any kind of normal life, sir. Let me let me disabuse you of that notion right now.
from me on a whim. This is not the first time she's done this to me. Anytime I have anything to say or I stand up to myself, this is the situation I get put in. Okay? We don't get to talk about when she was cheating on me when she was pregnant and I had to get a paternity test to find out if Kinley was mine. We're not talking about any of that stuff, though. She just wants to slander my name. The
Oh, you just said it. So we are talking about that stuff.
problem is I could slander her name with facts, and she can slander my name with lies. That's what this boils down to.
Oh, no, wait. I need
Thank you, Mr. Bondurant.
I need this guy
Ms.
right
Blessing?
now. I need it bad.
There we go. Again, Your Honor, nothing has been provided to substantiate Mr. Bondurant's statements of sobriety, statements that CPS is closed and unfounded. Nothing even, frankly, from the police indicating that it is an active investigation to substantiate his series of events, which are, unfortunately for him, contrary to the evidence that's been provided to the court. This isn't an issue of slandering one another, but I do believe that that's a big underlying issue between these parties' co-parenting relationships, and I think that that is borne out by the evidence that's been provided. It's an issue of safety and protecting these two young children, something that I don't believe Mr. Bondurant is currently capable of doing at this time. So we do believe that our requests are appropriate. We do believe that they are necessary in order to continue protecting these kids.
Thanks. Okay, I just wanted to circle back to that. The
And if I can add,
limitation.
Your Honor, if I could just add one more thing.
Sure.
CPS came to this house, and they were advocates for us keeping our children, okay? I've asked for these records, okay? I cannot make them work any faster, but what a lawyer can do that has no problem spouting off a bunch of wild, obscene comments that she doesn't know actually what she's talking about. She's literally just taking what Taylor Flick is saying, not even looking into it, not looking out for her client, because what's going to happen is I will be able to afford an attorney here soon down the road that will properly represent me, okay? And this will be something that this is not going to be over with. I can guarantee you that.
If this guy ever scrapes together the cash for an attorney, the first thing the attorney's going to do is look at this hearing and go, "What the hell do you want me to do now?"
Have proper representation, okay, and I have someone speaking for me on truths, okay, Taylor's lies are going to come out, and I will have full custody of my kids.
All right, thank you, Mr. Bondurant.
Is Taylor Flick like somebody? I've never heard of Taylor Flick.
I just wanted to circle back to the page limitation and just let Mr. Bondurant know where to find that. If you go to the Cowlitz County Superior Court webpage, which is cowlitzsuperiorcourt.us, and you look under rules, there's on the top left, one of the main headers, it says rules. And if you click on that, if you look at Rule 88, it'll give you the rule related to page links, so for future reference. So here there's a motion for adequate cause. Basically, has there been a substantial change for the court to look at making a change to the parenting provisions in the parenting plan that's been previously put in place? So here there's, obviously there's dispute between the parties as to what things mean or what's going on. As far as the DUI, we know that there was a prior DUI.
Oh, seriously? Is this a thing? I'll look. I don't know if I believe you.
Conviction in 2016. Apparently it was diverted. And so this current one, there's some ambiguity whether it was a DUI arrest or if it was some type of citation or what have you, and simply an arrest on a warrant. One thing I think is that rings loudly when you take into account the prior DUI in 2016, and then what Mr. Bondurant represented, that he said that, I believe, related to the overdose.
Oh no, I don't want to ruin it, but judge does all right in my estimation.
That when I look at that overdose issue, even if I take Mr. Bondurant's statements at face value, which I do, he said that there was an individual that they didn't know, they gave them a joint, and then they smoked it. And
Your Honor, it was one of my good friends' buddies. He knew him. I did not. So it was like we were in a circle, and a joint gets passed around.
right,
And
right. So with the joint,
Judge, these were some really credible drug addicts that I was dealing with here. It was very responsible the whole way.
passed around, it's fairly common knowledge in drug using circles that fentanyl gets laced with a bunch of stuff, including marijuana. So while the person there may be a friend of a friend, it's still placing confidence in that friend to vouch for this other friend that they got it from a clean source and there's no lacing is, at least in my opinion, reckless, because it's very common knowledge that happens with some regularity. So unfortunately, that occurred. Fortunately, the Narcan was administered, and thank goodness, both parents, Mr. Bondurant and his spouse, are still here. That's a beautiful, great, good thing. But I take that overdose issue and the consumption of marijuana of an unknown source with the prevalence of fentanyl. I take that into consideration with what I call kind of this glorification of drug culture or drug consumption. I recognize that marijuana is legal. It is legal. Alcohol is legal. Food is legal. We abuse a lot of those things. Many
Things just got awkward.
of us abuse alcohol. Many of us abuse marijuana. Many of us overeat. Many of us do a lot of things. We don't get enough sleep. And some of those things that we do impact parenting. So I say that because those things raise a level of concern that there is this maybe an over focus, or maybe that there's been a lack of volitional control when it comes to certain substances, pardon me, and it may have an impact on parenting.
Your Honor,
Issue of sexualized, this isn't an opportunity for back and forth discussion. I've heard from both parties, and I'm giving you my ruling at this point. So there's concern for sexualized behavior related to the French kissing incident. I read both parties, what you had to say about that. There's also issues related to, I'll leave it at that. So, there's also the issue of the driving license being revoked. And I recognize a lot of people that are revoked drive. In our size of our community, the size of distance between things, it almost becomes a necessity to drive. So I'm very aware that people who are suspended drive with regularity, if not infrequently. And Mr. Bondurant's own statement indicated 99% of the time I don't drive. There you go. So there's indications that if Mr. Bondurant were to drive and not be licensed and there were to be an accident, there could be some liability and concerns where the children may not be fully taken care of or provided for. That's a concern. That all leads me to believe that there is adequate cause. So I'll grant the motion for adequate cause to modify, pardon me, the parenting plan. There's also issues related to, one thing I forgot to mention was related to, I'm happy to hear that Mr. Bondurant's currently in treatment for past abuse of prescription pills. That's great. That's important and noble and good. And I'm glad he's doing that. When combined with the other concerns, I think that a new SUD evaluation with collateralized input from Ms. Flick would be appropriate. So I'm going to require that. Pending the outcome of that SUD evaluation, the supervision with the girls and visits of dad will be professionally supervised. once we get those results back, we can certainly or quickly look at that and change that if needs be. I will appoint a guardian ad litem to investigate the case. It'll be a county pay case, and they are to look into all issues related to parental, the well-being of the children, including SUD issues, driving status, any of the number of concerns that have been raised here today. So that's the court's order at this point. Does any party have any questions?
Yeah, my only question would be, so from here going forward, am I just not allowed to contact my children at all? Because that's fine
No,
if you
you
take
may.
that. Hang on, Your
You
Honor.
may.
Your Honor.
You
can
may.
I say
Your
something?
question, I'm entertaining questions at this point. Do you have a question?
Yeah, that's a question. I want to
Okay.
know how long you're
So
going to keep me
yes,
from my
yes,
kids.
you can have contact with your children. It'll be supervised visitation.
No, like over the
professionally
phone. I can't call
supervised.
my kids. I can't call my kids. I haven't talked to my kids in 4 months. That's not a problem. That's going to help with people's sobriety, Your Honor.
So no need to be confrontational with me, Mr. Bondurant.
I'm not being
If
confrontational.
you are, and if you would like to have telephone contact with your children, you could say, Your Honor, what about telephone contact with my children? I'd be more than happy to entertain that question.
You really want to watch the attorney's face. She gives some great expressions during this.
Your Honor, what about telephone contact with my children?
Ms. Bliss?
I don't necessarily think my client would have any issue with that so long as it's supervised.
I'm fine with telephone conversation between the father and his children. Pardon me, 3 times a week for up to 30 minutes. Do you have any other questions, Mr. Bondurant?
Sounds like you have more rights to my kids than I do. Nope.
Is that a question, sir?
No, I don't have a damn question for you.
Please refrain from swearing in my courtroom. The record will reflect that Mr. Bondurant exited the courtroom when I told him to abide by my rule. Ms. Bliss, if you'll provide a proposed order, and we will come back in 2 weeks.
Your Honor, I don't know, given his removal of himself, if you're willing to entertain this request, but with regard to those phone contacts, to limit the derogatory statements and conversations with the children, to obviously not include any litigation.
Given his inability to keep it together during today's hearing and his confrontational attitude and is quick to lose his composure, I'm revoking that permission. So there will be no phone contact until we come back again and we can have a discussion about his ability to moderate himself.
Very good. Do we want to set presentation for 2 weeks?
Yeah, let's set it for the 14th of November.
Very good. Thank you, Judge.
Great, thanks.
Oh man, I gotta get together.
Okay, so Judge is super mellow, but then he did bang him at the end. He was going to allow telephonic communication, and based on that little stunt, he's like, nah, he can't behave. We're not doing that. Can't phone his kids at all either, which I think was the right ruling for the right reasons, and he gave his reasons right there. All right, let me see here. I have one more. I haven't seen it, but we're having so much fun. Let me see if I can get this going. It's in Webster. Let's see if this is fun at all.
Very well, we'll take up your case then. We are on the record in case number 2021 TR 681, State of Kansas versus Melissa Poller, County Attorney Jill Gillette for the state, Ms. Poller in person, in custody, and pro se. Ms. Poller, I have before me a journal entry of failure to appear.
In custody and pro se is always a good start for Law Talk with Mike purposes.
And bond forfeiture, you were supposed to be here December.
Wait,
Let me check on this.
I don't think it was in
I
December.
believe you were supposed to go out and be processed at the county jail, and you never did that, did you?
No, I didn't. I'm processed now though,
Why did you not do as I'd ordered?
because I didn't have a ride and my mom's been sick. I've been taking care of my mother, which is
Did you
the
call
route that
and
I'm
tell,
in now.
did you call and tell anyone that?
Yes, I tried to call my attorney.
Right?
My attorney
All right, where are we now?
changed on me, but my mother was in the hospital.
All right. Well, how are you going to handle this driving while suspended and no proof of insurance? You said you have an attorney.
Yes, I would like to see if I could ROR and if I could get my own attorney. My daughter's willing to pay for my attorney so I can be home to take care of my mother.
Judge, these are the notes that I have in this case file.
Uh-oh.
11/9/21, defendant appears pro se to hire attorney. Need to get processed. She failed to appear to get processed. 12/3/21, defendant failed to appear, bench warrant, no bond, because of prior failures to appear. Warrant was previously entered. On 2/21/23, we were reset for hearing as she failed to appear, no bond hold, bond forfeiture, bench warrant. We're here today. Then there was a June 13th, 23. Defendant failed to appear in April, and she failed to appear again. So she was supposed to have Shannon Cooper appointed to her, which would be now Mr. Paul with the contract.
Have you ever had a failure to appear?
Possibly.
21st of 23, and in July we had issues with her again, and then there was a journal entry because Miss Cooper asked for a continuance, and then in September she failed to appear. She's had so many failures to appear on her bond forfeitures and for her hearing dates that she's generally only here when she's in custody.
I'm sorry, I don't have any transportation. And
Well, okay, you won't need to worry about transportation for your next hearing, Ms. Paula, because I'm going to, with this history of yours, I'm going to order that you be held without bond, and I'm going to, she hasn't had an attorney at all, Ms. Gillette?
yes, I have had an attorney.
Okay, hang on.
Shannon Cooper, because she was going to hire her own attorney and she never did. So we appointed her Shannon Cooper to try to get her case wrapped up. And then she got a bond and she never came back on it. So Ms. Cooper couldn't resolve her case. So
Okay,
now
well, she doesn't want Ms. Cooper anyway. She said she wants new attorney. We're going to give her
Well-
Richard Paul. You're going to stay in jail until your next hearing. And Missy, when can you fit her in? What is it, this Friday or next Friday maybe? I'll
I think Darren Patterson has openings.
fit her in.
The next traffic date is November 17th.
Oh God, I can't wait. Please don't make me wait that long. My mom's in the hospital. Please. Can I please get a bond? Please.
I've given you countless bonds.
Ma'am, I
Missy,
promise.
Please stop. Please, let me talk to Missy here a minute. Missy, we're not having any, is that 2 weeks from now?
It's Veterans Day and we're closed.
No, please, ma'am, I'll go on house arrest,
Please
anything.
stop. Please, I'm thinking this through and I need to think.
Sorry.
Can we, thank you. Missy, can we put her in maybe on a misdemeanor control docket? When's the next one of those?
If Ms. Gillette wants to prosecute, yes, November 7th, which is next Tuesday. at 3:30?
What do you think about that, Miss Gillette? Can we do it November 7th and you could be the prosecutor on it instead of Mr. Dean?
That's absolutely fine with me, Judge.
All right, November 7th at 3:30. That's next Tuesday, you said, Missy?
Yes.
And will Mr. Paul be here as far as you know on that day?
Yes, he's got other people on the docket.
Good. All right. So your next court date is November 7th, a week from today at 3:30. Mr. Paul will be your attorney. Deputy Lazar, is there any chance she and Mr. Paul will be able to talk? Will she be able to contact him or will he need to contact her?
We'll make it happen.
All right, thank you. I appreciate that, Deputy. So you and Mr. Paul can talk about this, but you need to make sure he knows that you don't come to court unless you're sitting in jail, and that's why we're doing it the way we are.
So there's no way I can get a bond?
I just can't trust you to do that.
Ma'am, can I do house arrest? Please, I have a baby at home to take care of and a mother. My mother just got out of the hospital. Please, Miss Webster, I swear I will be here. I will be here. My daughter will bring me, I promise. If not, you can put me in for the maximum. I don't care. Just please let me take care of my mom.
Here we can.
I'm gonna set your bond at 50,000 cash or surety required.
50,000?
50,000. I've got to make sure you're here. I mean,
I will make sure I'm here.
These charges are important, but they're not the end of
I
the
know.
matter. But you won't take care of them. The case alone is a 21 case. It's getting ready.
I know, and I'm sorry. I don't drive. I don't have a vehicle. I'm sorry. There's no way.
That's why you need to just sit in jail and get this resolved. But call Mr. Paul. If he sees something else that he can do for you, he'll do it. He's very diligent with his responsibilities.
You can't make it no lower than that.
Judge, I'll make sure Mr. Paul gets a copy of the file today and I'll make touch base with him today.
All right, thank you all. Nothing further. We'll be in recess. And Ms. Paula, you are remanded to the custody of the sheriff.
The wheels of justice are going to roll you right into the Wayne County Jail.
Well, there you have it. Thank you very much. Also from anonymous source. Good stuff. Good stuff. I was just going to do the one in Washington, but then we had that guy. Oh, he was a vibe in DeSanto today, and this one, and then we got Crying Karen just as a bonus. Just as a bonus. That's the way it rolls here at Law Talk with Mike. Good stuff. Thank you all for coming out. I really appreciate it. I'll see you all soon.